I'm going to get into this video about the lawyer for the cops. He's even got a little flag with a blue stripe on it and everything. I wanted to go over this lawyer's video that he made for cops, teaching the cops about Terry versus Ohio and what they need to know. And then you can now use it to your benefit. You know, I think it's important that, we understand what the opposition is being taught and what their legal theory, understanding the most invasive policy created by an unelected Supreme Court in 1968 called Terry versus Ohio, where the cops can run up and grab us based on officer safety. So just remember that every time you say to a cop, you're going to go hands-on, a cop can go hands-on with you anytime they feel like their safety is in jeopardy. And that could be at any moment, at any time. If they say that they feel as though they're in jeopardy, that officer safety is in jeopardy, then they can go hands-on and detain you based on their safety feeling. That's the law, how they feel. You know how we always say facts don't care about your feelings, but it matters in Terry versus Ohio, because if you feel like I'm going to beat you down, then you get to grab me and put me in torture cuffs and call it detained, when really it's arrested and you have a gun and I can't fight back and you're just scared. That's the law. So I think it's important that we all know exactly what that is. And so when I came across this video, I was like, I think that people have to hear what this. So if you take a look at this video here, if I'll blow it up big for you, over here in the upper left-hand corner, you got your terroristic gang symbol over here in the corner. You guys can see that right there. Everybody can see that. And then this is a tactical attorney. Obviously, I'm not going to subscribe. Police officers are expected to know the law like a lawyer. Put a 1 in the chat if that's not true. Put a 1 in the chat if that is a lie. Police officers are not expected to know the law like a lawyer. 2014, Heen versus North Carolina says they don't have to know the law like a lawyer. It starts with a firm grasp of the basic. So what is the basic? The basic is Terry versus Ohio. So that's what he's saying here. It starts with a firm grasp of the basic. So basic is that we get to grab you based on our feelings of whether or not we feel safe or not. And then in this episode, I break down the landmark decision of Terry versus Ohio. And why do they call it landmark? Because that means that multiple cases are going to hinge off of the Terry holding, like Pennsylvania versus Mims, that says you have to get out of the car in the name of officer safety, like Arizona versus Johnson, 2009, that says your passenger has to get out of the car in the name of officer safety, like Wilson versus Arkansas, 1995, that says the cops can no-knock raid your home if it's in the name of officer safety. They can't do it unless, of course, it's in the name of officer safety. There's over 100,000 raids on homes a year. And don't forget Tennessee versus Garner, that says that the cops cannot shoot you in the back as you run away, unless, of course, the landmark decision of Terry versus Ohio, unless the officer has objectively reasons in his mind that you're a danger to society as you run away. And then they can shoot you in the back as you run away under Terry versus Ohio. But Tennessee versus Garner says that you cannot shoot people in the back as they run away, unless, of course, the caveat is unless it's in the name of officer safety, from the landmark Supreme Court decision in Terry versus Ohio.
One of the most important cases that every police officer must know is the landmark decision in Terry v. Ohio. When properly applied, Terry v. Ohio allows an officer to prevent a crime from happening while also allowing the...
Okay, we got to stop right there. That's not true. Police officers solve less than 4% of Johnny-on-the-spot crimes. And that's a very, very high number. It's much, much, much lower. But that's the number that they tout.
The officer to protect themselves from a potential violent attack.
And what did I just say? The cop can grab you if he just believes or feels like maybe you might attack him.
But I see officers screw it up all the time. I'm going to break it down for you right now. What's up, everybody? Attorney Eric Scramlin with Tactical Legal Solutions here, and this is the Tactical In-Service Podcast, a podcast for law enforcement where I break down case law and training topics to help you, the law enforcement community, stay up on the law. Today, I'm going to be talking about a landmark decision, arguably one of the most important cases that every police officer must know, and a great tool for policing, and that is
a great tool, huh?
the landmark decision, Terry v. Ohio. I know this has been covered a million times by a million different lawyers and police officers, and you can find a ton of videos out there on YouTube. But I really wanted to address this basic topic in this episode of the podcast because in my career as a prosecutor, and especially now that I train, and then looking back to when I was defending officers in civil rights lawsuits, I would see this screwed up all the time. I see students mess it up all the time. It seems simple, but it's a little more complex because we have Terry v. Ohio, and then we have the case law that came after it. So I want to take a few minutes today and just kind of break down the Terry v. Ohio case. And I want to talk about a couple of aspects that every officer has got to know, like buried in your subconscious, because it's so important to know these basic terms about policing. In Terry v. Ohio, this landmark decision is something that every officer has to understand and know like a lawyer. So let's go over it. I'm going to break it down for you and kind of give you the context of what a lawyer should know and what you need to know because you're expected to be a lawyer. So
the police are not expected to be lawyers. We covered the case just 2 weeks ago. It's Heine, H-E-I-N-E-N, Heenan versus North Carolina. And cops are not expected to be lawyers at all. Matter of fact, they can make mistakes. And if it leads to reasonable articulable suspicion, it's perfectly fine. So what's he talking about?
You have to know it like a lawyer. So let's break down Terry v. Ohio. All right, I want to, before I dive in kind of all into the facts here, I want to give you a little bit of a context about Terry v. Ohio, because Terry versus Ohio came out, and I think it was 1968. The facts happened in 1963. So if we look at policing.
At 2 o'clock in the afternoon on Halloween Day, on what's equivalent to going down Broadway in New York City, thousands and thousands and thousands of people.
Prior to 1963, there were two types of police encounters. The first type of encounter was what we all know as the consensual encounter. So a police officer approaches someone on the street, they have a conversation, that person's not trapped, a reasonable person wouldn't feel like they couldn't leave whenever they want to. It's a consensual encounter. Consensual encounters don't raise the Fourth Amendment.
What he means is before 1968, not 1963.
Because the person's not seized, which is what the Fourth Amendment requires. So during a consensual encounter, a police officer can go and talk to someone. That was one way of a police-citizen encounter prior to Terry v. Ohio. The only other encounter that could happen between police officer and citizens would be an arrest based on probable cause.
That's right.
So you either have a consensual encounter or you have the police officer that has probable cause. They're now going to seize the person, so the Fourth Amendment applies, but they must have probable cause to arrest that person.
And what is probable cause? When you have broken the law.
There was nothing in between prior to Terry versus Ohio. We didn't have investigatory detention.
Exactly. And that's the problem.
Or reasonable suspicion.
That's
and
right.
We got that from the Terry case.
We got that. He's got a blue attorney stripe. He's got a blue stripe. He's got a blue stripe. We got that. So you took away our freedoms. And you now have reasonable suspicion, which is crap. Investigatory stop is crap.
So I wanted to put that into a little bit of historical context to kind of show you what it was like before Terry and what this did and how it added a third type of police-citizen encounter, the one that we use so often, reasonable suspicion, criminal activity is afoot. All right.
Right. And this is the problem. This is why this entire channel exists. Reasonable suspicion that criminal activity is afoot. Now, whatever that meathead is who went to that police academy for a couple weeks and then got OTJ, on the job training for 6 months underneath of another meathead, that person is now in charge of what's reasonably suspicious about you.
The facts of Terry versus Ohio, I really want to spend some time to tell you about Detective McFadden, who was the officer involved in the case. Detective, because it puts into context, you'll kind of see how the Supreme Court came to their decision, and a big part of it was Detective McFadden. Detective McFadden was a 39-year veteran with the Cleveland Police Department. He'd been assigned.
Okay, so McFadden was on the police department from 1924 until 1963, when he arrested John Terry for 39 years. So when he joined the police department in 1924, there was still enforcement of black codes. You understand? And in 1963, Martin McFadden was enforcing black codes because John Terry wasn't allowed to be milling around downtown Cleveland. He wasn't allowed to be downtown at 2 o'clock in the afternoon just hanging out.
Trying to patrol a particular area in downtown Cleveland for over 30 years. And he was out on this day in plain clothes. So if you have someone that's assigned to a particular area in a particular city for 30 years, do you think they're going to know everything there is to know about that area?
No, dude, I don't. I think what he was doing was blacks weren't allowed to be hanging around on Euclid Avenue, the most happening part of Cleveland. That's what I know was happening. Dunce cap, do your research.
Yeah, about what looks suspicious in that area. So Detective McFadden was...
He wasn't a detective. McFadden never made detective. McFadden never advanced. He stayed in the same position his entire career.
Extremely experienced detective for 30 years, assigned to that particular area of downtown Cleveland where the facts of Terry v. Ohio happened. Detective McFadden testified to knowing the area very well, to going out to a certain kind of street corner and watching the routine habits and behavior of people and knowing when something wasn't right.
Yeah, John Terry was mentally ill. He didn't look right. He never looked right. Look at his face. He looks like someone who's crazy. I'm sorry. If you have a crazy cousin, brother, uncle, and you look in their face, you can tell that they're crazy.
So that's kind of the context of what sets this up. So one day, I believe it was actually Halloween 1963, Detective McFadden's out on, his plain clothes in his particular area watching what's going on, and he sees two men standing on a street corner. I believe it was Huron and Euclid Street in downtown Cleveland. And the two men he sees...
Yeah, and just so you know, do a little more research, bruh. Euclid Avenue, downtown Cleveland, if you research the tapes and talk about what was going on in the early 60s, you dress to the nines. You look good. You don't go down to Euclid Avenue without shining like a diamond. Terry and Chilton were two black dudes. This guy here, his job was to make sure black dudes weren't just hanging around downtown. Get that black people out of here. That's what was going on in America, period. That was his job. Get rid of these black dudes.
He's is Terry and Chilton. And he's kind of watching these two guys because they're talking to each other. And then he's watching as one will walk down the street and then look into the window. And then he starts having a conversation with the other guy. Now the other guy goes down, looks into the window, comes back, having a conversation on the corner. And then this third guy, Katz, kind of comes in. He's kind of like coming and going as this is going on. But it's clear to Detective McFadden that these three men are having a conversation. And then 12 times, at least 12 times, he stays.
Okay, and this is not true. If you listen to the oral arguments of Terry v. Ohio, it was not 12 times. Listen, it was a couple black dudes milling around downtown who weren't supposed to be hanging around for that long. I'm telling you, you can do your own research on this. I've presented this. And then Katz was a white guy who knew these guys. Just listen to his BS story. He just doesn't know what he's...
He sees this go down, look into the window, come back, talk to each other. What does it look like they're about to do?
Bruh.
If you're the detective standing there, knowing this area that well, seeing this behavior, okay, you haven't seen a crime be committed. They're not doing anything illegal yet. But it looks like they're casing this place for a robbery, probably an armed robbery. So the detective comes in.
Okay, so what's your First Amendment? RAPS, religion, assembly. They have a right to assemble and mill around back and forth and be like, yo, did you see that white chick with the pretty hair? I mean, they're downtown hanging around all the whites. It's all whites. Unless you work for somebody, you don't belong downtown. You guys don't understand. The signing of the 1964 Civil Rights Act was not just 1954 happened, Brown versus Board of Education desegregated America, and 1954 happened and Brown versus Board of Education desegregated America, and then all the black people were free. No. Black people were not free. In fact, most of the police in America continued to enforce segregation. And that's why the 1964 Civil Rights Act was so huge, because then it really began to break the chains of segregation. What Martin McFadden was doing downtown was kicking blacks out of downtown. And they were milling around, and he saw them milling around, and he didn't like it. He said he didn't like the way they looked. So he took away their right to assemble. And on the process of him being this dunce cap copper, then the Supreme Court said, oh, he was a super cop, so now all cops are super cops, so we'll give them all this reasonable, articulable suspicion. If Martin McFadden could sniff out those blackies with those guns, then every cop can sniff out the bad person with the guns, which was who? The black people. The black people were the bad people. All the blacks were bad.
And seizes the three. I believe he got all three. I know Katz was kind of in and out, but I believe he seizes all three of them.
Yeah, Katz doesn't get charged because he doesn't have a gun on him and he's white.
And then he does something that we would later call a Terry pat or a Terry frisk, where he pats them down for weapons. And on Terry, he finds a 38 revolver concealed. Terry gets charged with carrying the concealed firearm. That's the crime in the case. Obviously, the armed robbery never happened because the detective prevented it from happening by seizing them beforehand.
Such a BS lie. Just so you guys know, Chilton and Terry and Katz all went to their deathbed saying, we were not going to stick up anything. We were not. John Terry spent the rest of his life in the insane asylum. After the Supreme Court upheld his conviction, he lived in the loony bin for the rest of his days. He never got out. He died there. He was crazy. He walked around downtown Cleveland like this, looking off and looking all crazy. And Martin McFadden didn't like the way he looked. That was his actual testimony. I saw them. I didn't like the way they looked. Yeah, the dude looked like he was wacky. He was. If you go out downtown LA, downtown New York, downtown Vegas, downtown Dallas, downtown Houston, you're going to see someone and they're going to look like that. And you're going to go, that person looks crazy. And they are. They're crazy. John Terry was mentally ill. That's all I'm saying. And they did not prevent a stick up. It's the lie that perpetuate for reasonable, articulable suspicion over you today. That's the lie perpetuated.
Now, remember what I said about the historical context here. At this time, there was only two types of police citizen encounters. One was the consensual encounter, and two was probable cause to arrest. Well, clearly this isn't a consensual encounter, and clearly they're seized. So the Fourth Amendment applies. But did he have the probable cause to arrest them? No, he didn't. The detective stopped them based on everything he saw, training, experience, what they were doing, looking in the window, going to the corner.
No. What they did is they created a caveat in our Fourth Amendment called reasonable articulable suspicion. Before that, it was a consensual encounter or there was probable cause for an arrest. That's what there should be today. Right now, today, especially with the camera systems we have. It could all be better. We wouldn't have to put up with any of this reasonable articulable suspicion garbage. This is why it's called a landmark case. It created new legal land. Think about it like that. New legal land. Now they park everything on top of two things: reasonable suspicion and officer safety. Both of those things came from the landmark decision in Terry versus Ohio. They created new legal landing for cops to violate your rights. That's the way you can think about it.
He was detaining them to try to investigate to see what the hell was going on. That's the issue that went to the United States Supreme Court. The issue was this type of stop that the detective did in this case and his subsequent frisk. So you had the two issues, the stop and the frisk, didn't violate the Fourth Amendment. And of course, the United States Supreme Court said that no, it did not violate the Fourth Amendment. Specifically, the court found it to be reasonable. And that's the touchstone of the Fourth Amendment, is reasonableness. Right. You always see the court come back to that. So the Supreme Court held that we now have a third category: consensual encounter, probable cause to arrest. And now, based on this case, an officer may temporarily detain someone to investigate if there's reasonable suspicion that criminal activity is afoot. The key being reasonable.
The Supreme Court added this. We didn't add this. 9 unelected people, one of them a member of the KKK, added this.
Suspicion. Now, that's a topic that we can discuss for a long time. I can do a several-hour podcast on that. I have a couple videos on that. I'll have a scroll on the screen. Go back, take a look at those. Reasonable suspicion has developed case by case throughout the years. But it goes back to Terry v. Ohio, and it's that standard of, can you articulate facts that let you as an officer infer that a crime is taking place or is about to take place or has taken place recently? If you can articulate those facts, Supreme Court says you can detain that subject to investigate and either confirm or dispel the suspicion. Now, it's limited, it's brief, and it's limited to investigating that particular crime that you suspect based on your reasonable suspicion.
Which is just made up garbage.
Now, if you develop probable cause during that quick investigation,
you don't develop probable cause. Probable cause is when you have broken the law. You don't develop probable cause.
You can arrest. If you don't, you got to let them go. That's an area that I see some problems with. It's limited. It's brief. You got to understand that. That was the point the court was saying, is it's reasonable for an officer to temporarily detain someone to either confirm or dispel the criminal activity afoot, the reasonable suspicion they've developed, but it's limited. Okay, you're not going to be able to keep them there for 2 hours while you investigate. If you develop probable cause, you arrest. If you don't, you got to let them go. It comes to an end. All right, so that's the Terry stop aspect, but the second part of it is where I see a lot of officers have confusion, and that's the Terry frisk aspect, because remember, the 2 issues that went to the court was, do we have a reasonable detention, which the court said yes, and they created that third category, reasonable suspicion, criminal activity afoot, but they also had to address the frisk because that was a search, and under the 4th Amendment, searches must be reasonable. Now, detective didn't have a warrant, clearly, and at that time, prior to Terry, we didn't have Terry frisk, so the court had to say, is this frisk for weapons reasonable under the circumstances? And the court said yes, it was, because the detective had reasonable suspicion to detain him, and the detective had reasonable suspicion that this person is presently armed and dangerous.
He did not have reasonable suspicion. He just didn't like them. He didn't like how they looked.
Based on the fact that they were about to commit a robbery, all the facts that the detective testified to, a reasonable officer could believe that someone about to commit a robbery would be carrying a firearm. Therefore, the detective had reasonable suspicion that this person was presently armed and dangerous. So that was the standard the court created. Number 1, you need reasonable suspicion criminal activities afoot to detain, but it's not automatic. This is a really important point I want to make with Terry v. Ohio. The court made very clear. In subsequent cases, Ibarra v. Illinois, there's tons of them where the court's made very clear. Just because you do a Terry stop, you cannot automatically Terry frisk. It's not an automatic thing. The Supreme Court stated you need to have reasonable suspicion criminal activities afoot to detain, and if you want to do a Terry frisk or a Terry pat for weapons, you must, in addition, articulate reasonable suspicion that they are presently armed and dangerous.
Is that what's happening, though? But is that what's happening? Let me go back right here. Is that what's happening? Is that what's going on? Must have reasonable suspicion criminal activity is afoot. I see people with cameras getting arrested all the time now. Reasonable suspicion, presently armed and dangerous. I see that it's so regular constantly that there's no reasonable suspicion, and there's no way the cop believes that you are presently armed and dangerous. If they thought you were presently armed and dangerous, then they wouldn't stand in front of my window broadside open. So this isn't being followed at all. That's why I'm saying we're not living under a rule of law. Even if the rule of law was Terry, we're not living under Terry. They're just making whatever they want up to be able to grab you and hurt you, because torture cuffs are always torture. Put that in the comments. Torture cuffs are always torture. Torture cuffs are always torture. There's not a time that they're not.
Reasonable suspicion that they are presently armed and dangerous. So you have to articulate the same level of facts that they're armed right now and dangerous. And I keep saying and because it's got to be both. Just because someone's armed doesn't necessarily mean they're dangerous. But think about the context of the Terry case, about to commit an armed robbery, those facts that indicate it, training experience, armed robbery.
So they just make up nonsense. It's all nonsense. The case had already been written for a previous case.
Weapons.
The opinion had already been written so that they could do pat downs.
You have a reasonable suspicion to believe they're presently armed and dangerous. So you have to be able to apply that to the situations that you get into. If you do a Terry stop, you need to articulate your reasonable suspicion for the stop. If you want to then Terry frisk, it's not automatic. In addition to your reasonable suspicion for the stop, you got to develop reasonable suspicion that they're presently armed and dangerous.
You have to develop your reasonable suspicion. Well, they didn't look me in the eyes. They were looking me in the eyes. They were talking a lot. They weren't talking at all. Everything's suspicious.
How do you do that?
How do you do that? So the question he asked was, you have to build your reasonable suspicion. Well, how do you do that? You start talking to them, and then if they decide they're not going to answer questions, well, that's suspicious. If they decide they're going to answer questions, well, then that's suspicious. If they look at you when they're talking to you, well, that's suspicious. If they're not looking at you when they talk to you, well, that's suspicious. If they're looking away and out the window, if their thumbs are twiddling, if their foot is shaking, if they're sweating, if they're very calm, if they're very excited, if they put their glasses on and take them off again several times, that's suspicious. Whenever the cop decides what you're doing is suspicious. So that means there's always reasonable articulable suspicion. You are always suspicious. He was talking with his hands too much. That made me suspicious. He was very stiff. He wasn't moving when he was talking. That made me suspicious. He didn't look me in the eyes when he was talking. That made me suspicious. He was staring me right in the eyes when he was talking, and that made me very suspicious. No matter what you do, that cop can say it was suspicious.
There's been a risk. It's not, you need to articulate your reasonable suspicion for the stop.
Listen,
if you want to then Terry frisk, it's not automatic. In addition to your reasonable suspicion for the stop, you got to develop reasonable suspicion that they're presently armed and dangerous. How do you do that? There's been a lot of cases that have come out since Terry v. Ohio, but it says to just look for obvious things. Do you see printing? A bulge? Does it look like they're carrying a gun? That's reasonable suspicion they're presently armed and dangerous. What's the type of crime?
And who makes that decision that they think they see a bulge? The cop does. You can't say that he didn't say that he thought that he saw a bulge on you.
You know, did you stop someone for stealing a candy bar, or did they just commit an armed robbery? Two different levels of crime. Two different ways of getting to reasonable suspicion. You're not going to be able to get there on some low-level offense versus an armed robbery where guns are used. What's their criminal history? All right, what's their demeanor?
What's their criminal history? And you're just going to tell him that information because you're just going to open up like a flower and answer any question for him.
Assault indicators. All these things go into the criminal history. All right, what's their demeanor? Pre-assault indicators.
Pre-assault indicators. What are your pre-assault indicators that I am going to decide that I'm going to fight a cop who has a gun, a taser, a stick, but most important, a radio, and likely I'm on camera. I want to commit multiple felonies. So he's saying, what is their pre-assault indicators? Once again, the cop is just making up that I saw pre-assault indicators. Well, what were they? He clinched up his body and did this because I thought the cop was going to punch me and I want to block my face. What are your pre-assault indicators for the cop you're going to attack? Go ahead, put in the comments. What is your pre-fight indicators for when you want to fight cops? You know what I do before I want to fight cops? I make sure my will is done. Yeah. I call up my legal friend and I'm like, hey, legal friend, is my will done today? And he's like, it is. There's my pre-fight indicator for all the cops I want to fight.
All these things, robbery, 2 different levels of crime. You know, you stop someone for stealing a candy bar.
You know, if you stop someone for stealing a candy bar today, you must go down or they will kill you.
Or did they just commit an armed robbery?
Well, if they committed an armed robbery, bro, there'd be sirens and there'd be shooting before they even got up to him.
2 different levels of crime, 2 different ways of getting to reasonable suspicion. You're not going to be able to get there on some low-level offense versus an armed robbery where guns are used. What's their criminal history? All right, what's their demeanor, pre-assault indicators? All these things go into the analysis. But what that's for another day, and you can watch some of my videos on that. The point I want to make from Terry v. Ohio is that it's a landmark decision. That's a great tool for law enforcement.
It erodes our Fourth Amendment.
That it's a landmark decision. That's a great tool for law enforcement.
It completely erodes our Fourth Amendment where we don't have any rights.
It must not be abused.
It's abused every day, bruh.
And this is something that will draw you into lawsuits if you don't have a full grasp of it.
And that's why I'm suing so many cops, because they don't know what they're doing.
The 2 things you've got to know about Terry v. Ohio. Number 1, reasonable suspicion criminal activity is afoot.
This is why Brandon Bork is going to lose in Las Vegas.
Is the detention part of it. And you have to articulate those facts. It's a brief detention. Confirm or dispel. If you don't develop probable cause in a reasonable amount of time, you let the person go. If you do develop it, you can arrest them. If it's, you know, depending on the laws in your state. The next part of that is you got to understand that a Terry frisk or a Terry pat is not automatic. In addition to the stop, you must identify and articulate facts, reasonable suspicion that they are presently armed and dangerous.
So that's your defense right there. When the cop walks up to you and he says, I want to pat you down for weapons, you can ask him, do you believe that I'm armed and presently dangerous? Do you really think you need to pat me down because you believe I'm armed and presently dangerous and that you are in danger if you don't check me for weapons? And if you can say that and do it with conviction, then you can avoid some cop putting his filthy paws all over you. So there it is right there. You must believe that I am armed and presently dangerous, and you must have a reasonable suspicion that criminal activity is afoot. Meaning that you have to be able to articulate why you think, number 1, I'm armed, which is fine because you can probably see my gun. I usually carry it around. But number 2, how am I presently dangerous? I've been on Earth for over 40 years. I wasn't presently dangerous any other time previously. Why am I presently dangerous now? Because you're here and you're scared? That's not a reason why you need to put your hands all over me. I'm not presently dangerous to you or anybody else. Especially, I would say the most dangerous person here that's armed and presently dangerous is you, Copper. You're the person who's armed and presently the most dangerous person here because you're scared. You're scared of everybody here.
So if you understand those 2 things, that's the basics here. I encourage you to read the case. It's really well written, and it's not like a legalese thing. You can tell that the Supreme Court said, yeah, this detective had all this experience in this area.
Okay, that's a lie. Listen, Hugo Black was a lifetime member of the KKK. His oral arguments, he asked the attorney, you mean he can just ask him questions and then he don't got to answer them? He can just go on off? And the attorney, Louis Stokes, for John Terry says, that's correct, Your Honor. He goes, oh, that's what I thought you meant. Bruh. I mean, someone can let him know, bro, before you do breakdowns of cases, there are people who dedicate their whole lives to understanding, cases. So you might want to do a little research, bro.
Yeah, and you can see the articulation of facts versus conclusions as a problem.
No. You don't know the facts of who was on the Supreme Court. Earl Warren locked up 100,000 Japanese in Korematsu versus United States. I believe that's 1943. He gets put in the internment camp. He gets out of the internment camp because FDR put internment camps in America. And then Korematsu versus the United States, I think it was 45 or 46, 1945 or 1946. Korematsu, Korematsu, Korematsu versus the United States. And in that case, it's where Korematsu sued the federal government, sued Franklin Delano Roosevelt for locking him in an internment camp. And then because FDR had appointed 8 of the justices on the Supreme Court, including Hugo Black, the first one, the member of the KKK, then what happened was they said, not guilty. And Korematsu, there was what they say. It was justifiable why we locked up 100,000 Japanese in concentration camps in America. So you guys can look that case up. But Earl Warren was the guy who advised Franklin Delano Roosevelt to lock up 100,000 Japanese people. And now Earl Warren with Hugo Black, lifetime member of the KKK, along with Thurgood Marshall, who's on the Supreme Court for the first year of his tenure on the Supreme Court, he votes for Terry laws because he's told that if he doesn't, he's going to have problems.
Prosecutor, I hated seeing I stopped the subject for being suspicious. That's a conclusion. That's what Terry Ohio's saying you can't do. You need to articulate specific facts. You need to put in your report, what are they doing that makes it look suspicious? Are they pacing around, looking into a window, going to a corner, having a conversation, walking back down, looking in the window? Those are the facts you have to articulate. Being suspicious.
Korematsu is 1944. So I think it's 1944.
Suspicious is not reasonable suspicion. You got to articulate the facts. And don't forget, with the Terry frisk, it's not automatic. You must identify facts to indicate they're
It was 1944.
presently armed and dangerous in order to do that Terry frisk. So 15 minutes. I covered Terry v. Ohio. I hope that helps give you a little bit better understanding. If you want some more information on this, you can go to my website at tacticalattorney.com. I have a full Fourth Amendment course where we really dive deep into this.
So pretty cool. Pretty cool. I mean, if you guys don't know what Earl Warren actually did, and you know the dude that guy is, it's, you know, when I was doing deep dives, and I'm still going to show you guys with my wall game I've created, but when I did deep dives on constitutional history and constitutional law and case law and landmark cases that you have to know, and I was really digging into my studies, Earl Warren was one of these characters that on the glance, when you look at him and you look at the cases that he was involved in, you think to yourself initially, without really doing a deep dive into who Earl Warren was, you think this is a great man who desegregated America in 1954, and that desegregation process, you know, then took multiple presidents and the National Guard and the things that had to happen after that desegregation process. But then when you research and you dig into who Earl Warren was, and you find out that he was the one who advised Franklin Delano Roosevelt to lock up 100,000 Japanese people because of the kamikaze bombers that Japanese were doing. But then we find out later in life that kamikaze bombers and the Japanese fighter pilots, a lot of the times the people, when they were going out, only gave them enough gas to get to Midway. They didn't give them enough gas to get back. And so they had no choice. It wasn't like they chose it. They just got a half tank of gas in their plane, enough to get there but not back. And so then Earl Warren was a Freemason. He was president of the Freemasons for 5 years. So if you don't know what Freemasons do, they write the code or the structure of society, and they decide how things will be laid out. It's really a scary thing what Earl Warren was, and publicly. And it wasn't like he was hiding it. And then in 1954, he desegregated America. But what people don't know is a lot of the reasons why he desegregated America was because he needed to know what was being said in black hospitals and in black bars and in black restaurants and in black establishments. What were they planning? Were they planning and colluding and maybe planning attacks? Earl Warren was, I mean, I hope there's a hot place in hell for him. All right, I've been just bloviating. I'll get the flock out of here.